interrupt. There's one grant of standing, and the norm is with one grant of standing, there is one counsel or presentation, and it's a bit unusual.
Justice Rouleau is not pleased with this panel as he gives an exception for one lawyer to speak. This is a cautionary tale for Canadians. The use of the Emergencies Act raises questions. Did the ends justify the means? Jason Beachman, lawyer for Crowdfunding, responds. This is a very important panel to watch. Please especially pay attention to the third lawyer here. As one lawyer says, the world is watching. Here's the clip.
My name is Jason Beachman, and I'm here today as counsel for the National Crowdfunding and Fintech Association. The NCFA is Canada's largest industry association, representing crowdfunding platforms and fintech startups. The NCFA sought the right to participate in these hearings so that it could provide a voice for these emerging industries and technologies. We are here to comment on the fact-finding and policy review functions of the Commission with respect to two issues set out in the terms of reference. First, the impact of domestic and foreign funding, including donation crowdfunding platforms. And second, the impact, role, and sources of misinformation and disinformation, including the use of social media. Our hope is that through this process, the Commission will strive to understand whether and how misinformation and disinformation about crowdfunding and cryptocurrency influenced the decision to make orders under the Emergencies Act that targeted and restricted the use of these technologies. In his expert report submitted to this commission, Professor Ryan Clemens of the University of Calgary highlighted that the temporary orders made under the Act with respect to crowdfunding have been permanently crystallized in extensive regulation of the industry under the Proceeds of Crime, Money Laundering, and Terrorist Financing Act. These regulations were exempted from the ordinary cabinet requirement to pre-publish regulatory proposals for public comment and consultation. The explanation provided for this exemption was that the events leading to the use of the Emergencies Act provided sufficient rationale to waive the obligation of due process and to confer and consult. The use of extraordinary powers under the Emergencies Act raises questions. Questions of whether the ends justify the means. In the case of crowdfunding and fintech, the end result. Excuse me, it was an interruption there. In the case of crowdfunding and fintech, the end result is that laws were passed without public scrutiny or due process. This presents a cautionary tale for Canadians, and we will all benefit from scrutiny by this Commission into whether it is appropriate to deploy these extraordinary powers when the end result may be the subtle and not so subtle erosion of the rule of law. The NCFA looks forward to the Commission's efforts to examine these issues and to the opportunity to participate in that process. Thank you.
Merci, thank you. I can now call on the National Police Federation.
Yes, good morning, Commissioner and Commission Council. Thank you. My name is Nini Jones, and I am here along with my colleague, Lauren Pierce. We are both on Zoom today, and my colleague, Jen Del Riccio, who is present in person. And together we represent the National Police Federation. The National Police Federation is the exclusive bargaining agent for approximately 20,000 RCMP members and reservists below the rank of inspector. The RCMP, and by extension the NPF's members, were the source of the largest police response to the convoy and the blockades in Ottawa, as well as in every other location throughout Canada, including the BC occupation, the Alberta occupation, Manitoba, as well as assisting in Windsor. In other words, the RCMP were the police officers charged with responding to the situations created by the convoy across the country. The NPF intends to participate with a particular focus on the scope and the limits of our members' policing authority and their policing jurisdiction. And we are particularly interested in the divided jurisdiction and the issues that arose in the city of Ottawa, where police responses came from the OPP, the Ottawa Police, and the NPF's members employed by the RCMP, along with the Parliamentary Protective Services. Those are the areas of particular interest for the NPF, and we look forward to assisting the Commission and the Commissioner with those issues as they arise through this proceeding. Thank you so much.
Thank you. If I could now call on the Canadian Constitution Foundation and Professor Alford Yes, go ahead.
Thank you. Good morning, Commissioner.
Morning.
My name is Sujit Chaudhry. I am co-counsel for the Canadian Constitution Foundation. My co-counsel is Janani Shanmuganathan, and we are both on Zoom, although we do hope to attend some of the proceedings in person. As you indicated, Commissioner, the CCF has been granted standing jointly with Professor Alford. I would ask that we reserved a minute at the end of our remarks for him, and we would ask that you recognize him, please, when I conclude.
Well, if I could just interrupt, there's one grant of standing, and the norm is with one grant of standing, there is one counsel or presentation, and it's a bit unusual, and I don't think that should be the practice. The reason they were put together as one was that we streamline the process. I'm prepared to make an exception for today, but that is not because I assume you've prepared on that basis, but you should not, as a rule, proceed in that manner. If I can ask you to coordinate your presentation, whether it's Mr. Alford or you or Ms. Shanmuganathan, that's up to you, but I don't want it to break down into different parties. There are many other organizations that are sharing a standing, and they've all cooperated to have one presentation. So with that caveat, Mr. Chaudhry, you can go ahead on this exceptional basis today.
And thank you, Commissioner. And we did check in with Commission Counsel before we decided to proceed this way, and so we appreciate your forbearance in this exceptional circumstance. Commissioner Rouleau, I have 4 points to make in my introductory remarks. The first is that I would like to introduce the CCF. The CCF is a legal charity which is dedicated to defending fundamental freedoms in Canada, particularly the freedom to think, believe, and express controversial or dissenting ideas and opinions. The CCF would like to publicly express its appreciation to you, Commissioner Rouleau, for granting its standing before the Commission. Second, the CCF sought standing to assist the Commission because it will address questions that are core to our mandate. The emergency proclamation and emergency measures regulations severely restricted the rights to freedom of expression, assembly, and association. The emergency economic measures order chilled freedom of expression by deterring donations to organizations opposed to the public order emergency, such as the CCF. For the CCF, the fundamental question is whether the condition in the final clause of Section 3 of the Emergencies Act was met, that the Ottawa protests and border blockades could not be effectively dealt with under any other law of Canada, federal, provincial, or municipal. This clause codifies the requirement that the Emergencies Act is a last resort, which can only be triggered when all other legal tools fall short. Third, although the Commission will necessarily focus on recent events, a sense of history should frame how it approaches this task. The Emergencies Act is a successor to the discredited War Measures Act, which was abused during the FLQ crisis in Quebec. The Emergencies Act, especially the last resort clause, was drafted to ensure that the act could never be used by a federal government against its political opponents. For 34 years, the Emergencies Act was never used. The public order emergency of 2022 was a historic first. But now that the glass has been broken on the act, it can be used again. The act was used by this government against individuals protesting vaccine mandates, but a future government of a different political stripe could use the act in response to protests against pipelines or climate change. When the Commission asks hard questions about the act's use in 2022, the Commission must also focus on the act's potential misuse in the future and protect the right to protest, parliamentary democracy, and federalism. And what the Commission says matters not just to Canada, but globally, where the use of emergency powers is on the rise. The world will be watching our work. Fourth, the CCF would like to thank Commissioner Rouleau and Commission Council for taking on this enormous task of public service in an extremely tight timeline on an issue of singular and momentous significance to Canada. We look forward to assisting you in any way possible. Thank you.
Thank you. Thank you.